Chapter 1 of the Law and Medical Men. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. The Law and Medical Men by Robert Vashon Rogers. Chapter 1. Early Practitioners and Laws. The first medical practitioners in England, of whom we have any record, were the Druids. These philosophers, theologians, and soothsayers also practised medicine and surgery, and were skilled in anatomy and physic. To add to the veneration in which they were held, to impress the ignorant masses with the idea that they had power with the gods and could prevail, and perhaps to cultivate a belief in the efficacy of the remedies provided, they mingled incantations and charms with their medicaments and nostrums. Their panacea was the mistletoe, cut from the sacred oak, with a consecrated hook of gold held in holy hands, on a mysterious night when the propitious beams of the waxing moon fell upon it, wrapped for a while in a sanctified cloth, and treasured up in the holy of holies of the woodland god. This strange parasitic growth was deemed possessed of many virtues, and was named All Heal. Two other herbs, the Selago and Samulus, were also in those days highly valued for their medicinal efficacy. To every healing herb a divinity was assigned by the Druids, and the good gods were ever ready to help suffering humanity against the evil genii who presided over the poisonous and unwholesome. These priests also considered the creeping through tolmens, or perforated stones, good for many diseases. Their best charm, however, was the anguinium, or snake's egg, produced, 'tis said, from the saliva and frothy sweat of a cluster of snakes writhing in a tangled mass, tossed in the air by the fierce hissings of the serpents, and caught ere it fell to the ground in a clean white cloth. A genuine egg, though encased in gold, would float against a running stream and do many other marvel. The Druid seems to have been a herbalist, a believer in the faith or prayer cure, as well as a homeopathist, for in taking the diseased plant, the mistletoe, to cure diseases, he anticipated the doctrine of similia similibus curantur. Even in those old days, according to Tacitus, there were female physicians who competed with the practitioners of the other sex. The wives of the Druids exercised the calling of sorceresses, causing considerable evil by their witchcrafts, but caring for warriors wounded in battle. Later on, women seem to have enjoyed a pre-eminence as physicians and surgeons in England. Thus we are told that a maid treated a wounded squire. Meekly she bowed down to wheative life, yet in his frozen members did remain, and feeling by his pulses beating rife, that the weak soul her seat did yet retain, she cast to comfort him with busy pain. Into the woods thenceforth in haste she went, to seek for herb that mote him remedy, for she of herbs had great intendiment. There, whether it divine tobacco were, or panacea or polygony, she frowned and brought it to her patient dear, who all this while lay bleeding out his heart blood near. The sovereign weed betwixt two marbles plain she pounded small, and did in pieces bruise, and then atween her lily hands twain into his wound the juices thereof did scruse, and round about, as she could well it use, the flesh therewith she suppled, and did seek to bate all spasm and soak the swelling bruise. And having searched the intues deep, she with her scarf did bind the wound from cold to keep. Of fair Nicolette we read, Her strength alone thrust deftly back the dislocated bone, then culling various herbs of virtue tried, while her white smock the needful bands supplied. With many a coil the limb she swathed around, and nature's strength returned. Chirurgery, or surgery, that is, manual application, appears to have been the earliest branch of the healing art. We are told of a wonderful cure effected upon Queen Elgiva, whose beauteous face had been mutilated by the brutal clergy. Many superstitious practices were in the early days mingled with the operations of the surgeons, as well as of the physicians. History speaks of a man the muscles of whose legs were drawn up and contracted so as to defy all the skill of the surgeons, until an angel advised wheat flour to be boiled in milk, and the limb to be poulticed with it while warm. Then all was well. From the 10th to the 12th century the practice of medicine and surgery in England was almost exclusively in the hands of the monks and clergy. So lucrative did they find it, that many of the monks devoted themselves entirely to it, to the utter neglect of their religious duties. This the authorities of the Church disapproved of, and made many attempts to restrain. At last, in 1163, it was enacted by the Council of Tours that no clergyman or monk should undertake any bloody operation. From that time the clerics confined themselves to prescribing medicines, and the practice of surgery naturally fell into the hands of the barbers and smiths, who had previously been employed as assistants and dressers to the ecclesiastical operators. The smiths soon found that most of the business was absorbed by the barbers. The latter kept little shops for cutting hair, shaving, bathing, and curing the wounded, especially about the royal palaces and the houses of the great. The shops were marked by a striped pole and a basin, symbols that all the king's subjects might know where to apply in time of need, the fillet around the pole indicating the ribbon for bandaging the arm in bleeding, and the basin the vessel to receive the blood. The barbers became so important that in 1461 the freemen of the mystery of barbers, using the mystery or faculty of surgery, obtained a charter from Edward IV, and were incorporated under the name of the Company of Barbers in London, and none were allowed to practise save those admitted by the company. Although this charter was several times confirmed by subsequent kings, yet side by side with the regular barber surgeons there grew up a body of men who practised pure surgery, and who actually formed a company called the Surgeons of London. In 1540, by Act of Parliament, these rival companies were united and named the Masters or Governors of the Mystery and Commonalty of the Barbers and Surgeons of London. The third section of this Act, after reciting that persons using the mystery of surgery oftentimes meddled and took into their cure and houses people infected with pestilence, great pox, and other contagious infirmities, and also used or exercised barbery, as washing or shaving or other feats thereto belonging, which was very perilous for infecting the king's liege people, resorting to their shops and houses, and there being washed and shaven, enacted, that no manner of person within the city of London, suburbs of the same, and 1 mile compass of said city of London, after the feast of the Nativity of our Lord God then next coming, using barbery or shaving, or that hereafter shall use barbery or shaving within the said city, etc., he, nor they, nor none of them, to his, her, or their use, shall occupy any surgery, letting of blood, or any other thing belonging to surgery, drawing of teeth only excepted. And furthermore, in like manner, whosoever that uses the mystery or craft of surgery within the circuit aforesaid, as long as he shall fortune to use the said mystery or craft of surgery, shall in no wise occupy nor exercise the feat or craft of barbery or shaving, neither by himself nor by one other for him, to his or their use. And moreover, that all manner of persons using surgery for the time being, as well freemen as foreigners, aliens, and strangers within the circuit aforesaid, before the feast of St. Michael the Archangel next coming, shall have an open sign on the street side where they shall fortune to dwell, that all the king's liege people there passing may know at all times whither to resort for remedies in time of necessity." In 1745 this union of barbers and surgeons was dissolved, or, apparently, the surgeons ousting the barbers, received a new name and all the privileges of the old company, with the exclusive right to practise within London and for 7 miles around. In 1800 the Surgeons' Company was called the Royal College of Surgeons in London, and this in 1843 was changed to that of the Royal College of Surgeons of England. In Scotland, at a very early day, the chirurgeons and barbers were united, and enjoyed many rights and privileges. In 1505 the crafts of chirurgery and barburies were formed into a college or corporation by the Town Council of Edinburgh, and became one of the 14 incorporated trades of the city. George III. erected this corporation into a royal college, and now it is known as the Royal College of Surgeons of Edinburgh. In 1599 James VI., to avoid the inconvenience caused by ignorant, unskilled, and unlearned persons, who under the colour of chirurgeons are in the habit of abusing the people to their pleasure, and of destroying thereby infinite numbers of his Majesty's subjects, incorporated the faculty of physicians and surgeons of Glasgow, and gave them jurisdiction over the city of Glasgow and the adjoining counties. A recent Act of Parliament has very much shorn the privileges of this faculty. In Ireland the fraternity of barbers and chirurgeons of the Guild of St. Mary Magdalene was incorporated by Henry II. The apothecaries belonged to this body until 1745, when, with the aid of a statute, they set up for themselves as the Guild of St. Luke, or the Worshipful Company of Apothecaries. In 1784 the regularly educated surgeons of Dublin became incorporated under the name of the Royal College of Surgeons in Ireland. In the 12th century medicine seems to have been first studied as a science in England. The universities enacted that none should practise physic without passing through a certain course of study. In the 14th century the degree of Doctor of Physic was by no means uncommon. For many years physicians were greatly aided in chemistry and medical science by the discoveries of alchemists, and the search after the philosopher's stone and the elixir of life gave many useful hints to practitioners. Chaucer well describes a Doctor of Physic in the prologue to the Canterbury Tales, and gives an insight into the state of medical knowledge in the 14th century. "He was grounded in astronomy, he kept his patient a full gret del in hours by his magic naturel. He knew the cause of every malady, were it of cold, or hot, or moist, or dry, and when engendered, and of what humour. He was a very parfait practiseur, the cause ye know, and of his harm the rote. Anon he gave to the sick man his bote. Full ready had he his apothecaries to send him drugs, and his lettuaries for each of them made other for to win. His friendship nas not new to begin. Well knew he the old Esculapius and Dioscorides, and eke Rufus, old Hippocras, Halley and Gallian, Serapion, Rhasis and Avicen, Averrois, Damascene and Constantine, Bernard, Gatizan and Gilbertine. Of his diet measurable was he, for it was of no superfluity, but of great nourishing and digestible. His study was but little on the Bible." In 1421, under Henry V., an Act was prepared providing that "no one shall use the mystery of physic unless he hath studied it at some university, and is at least a bachelor in that science," and saying, "The sheriff shall inquire whether any one practises in his county contrary to this regulation, and if any one so practise physic he shall forfeit £40 and be imprisoned, and any woman who shall practise physic shall incur the same penalty." But this appears never to have become law. It was not, however, until the beginning of the 16th century that modern British medical practice may be said to have commenced, and in 1511 was passed the first statute for regulating the medical profession. From the preamble of this Act we learn that physic and surgery were then practised by ignorant persons who could tell no letters on the book, and by common artificers, smiths, weavers, and women, who took upon themselves great cures, partly using sorcery and witchcraft, partly applying very noxious medicines to the disease. Many years after this, however, were to be found those who, though not ignorant persons, approved of what would now be called sorcery, witchcraft, and noxious medicines. Bacon gives the following as infallible cures for the whooping cough: let a piebald horse breathe on the patient, give him fried mice, 3 a day for 3 days in succession, pass the sick person 9 times under the belly and over the back of a donkey, feed the patient on currant cake made by a woman who did not change her name when she was married, or hold a toad in the mouth that it may catch the disease. Burton, the anatomist, says that an amulet consisting of a spider in a nutshell, lapped with silk, is a cure for ague. Graham, in his Domestic Medicine, prescribes spiders' webs for ague and intermittent fevers. By the statute of Henry, the profession was for the first time divided into physicians, surgeons, and apothecaries, a division still kept up in England. It also enacts, under a penalty, that no physician or surgeon shall practise in London or within 7 miles of it without examination by the Bishop of London, or the Dean of St. Paul's, and 4 doctors of physic, nor out of the city or precinct, but if he be first examined and approved by the Bishop of the diocese or his Vicar General, calling to them such expert persons in the same faculty as their discretion shall think convenient. Fancy a D.D. sitting in judgment on an M.D. How orthodox and regular in his attendance at church would the latter have to be! However, 14 and 15 Henry VIII, Capita 5, vest this power of examination in the President and Elects of the College of Physicians of London. The Royal College was founded in 1518 by letters patent from the King. Power was given to it to make laws for the government of all men of the faculty of physic in London and within 7 miles, and for the correction of the physician within those limits and their medicines, and none could practise within those limits without a licence. Shortly after, an Act of Parliament confirmed this patent, so that none could practise in England without the licence of the college, save graduates of Oxford and Cambridge. Subsequently, fellows of the college were given power, together with the warden of the Apothecaries' Society, to enter the houses of apothecaries in London, to examine their wares, drugs, and stuffs, and to burn and destroy those that were defective. In 1560, by 32nd Henry VIII, Capita 40, surgery was declared a part of physic, and the practice thereof was thrown open to all of the company or fellowship of physicians throughout the realm. Not long afterwards, the Parliament of this reforming king seems to have changed its mind and made a move in the direction of free trade in physic, and by 34 and 35 Henry VIII, Capita 8, any man or woman was permitted to practise to a limited extent. We fancy we can trace the influence of the sturdy king in the provisions of this Act, which was entitled, "An Act that persons being no common surgeons may administer outward medicines notwithstanding the statute." The statute after referring to the Act passed in the 3rd year of the king's reign, which imposed penalties upon those who should practise as physicians or surgeons without being examined and admitted, goes on to say, "Sithence the making of which said Act," that of 3 Henry VIII, "the company and fellowships of surgeons of London, minding only their own lucres, and nothing the profit of ease or the diseased patient, have sued, troubled, and vexed divers honest persons, as well men as women, whom God hath endued with the knowledge of the nature, kind, and operation of certain herbs, roots, and waters, and the using and ministering of them to such as be pained with customable diseases, as women's breasts being sore, a pin and the web in the eye, uncomes of hand, burnings, scaldings, sore mouths, the stone, strangury, sorcelin, and morphers, and such other like diseases, and yet the said persons have not taken anything for their pains or cunning, but have ministered the same to poor people only, for neighbourhood and God's sake, and of pity and charity. And it is now well known that the surgeons admitted will do no cure to any person but where they shall know to be rewarded with a greater sum or reward than the cure extendeth unto. For in case they would minister their cunning unto sore people, unrewarded, there should not so many rot and perish to death. for lack of help of surgery, as daily do. But the greatest part of surgeons admitted have been much more to be blamed than those persons that they trouble. It further states that, although the most part of the persons of the said craft of surgery have small cunning, yet they will take great sums of money and do little therefore, and by reason thereof they do oftentimes impair and hurt their patients rather than do them good. In consideration whereof, and for the ease and health of the king's poor subjects, it was enacted that it should be lawful to every person, having knowledge and experience of the nature of herbs, etc., to practise and minister them without suit or vexation. Here is evidence of the existence of herb doctors, hydropaths, and lady physicians in those days. Numerous Acts of Parliament have been passed touching the medical profession since the days of bluff King Hal, one under James I. to prevent popish recusants practising physic, or using or exercising the trade or art of an apothecary; another under William and Mary for exempting apothecaries from serving as constables or scavengers; another for exempting spirits and spirituous liquors used by physicians, etc., in the preparation of medicine from duty, and others for purposes too numerous to mention. But it is the Medical Act of 1858, as amended by the 22nd Victoria Capita 21, that now governs the practitioners. In 1681 the Royal College of Physicians of Edinburgh was incorporated, and power was given of licensing practitioners and of preventing others practising. In Ireland, although the idea had been conceived many years before, it was not until 1654 that a body called the President and Fraternity of Physicians was founded. Subsequently this company was incorporated, and powers given to it very similar to those enjoyed by the London College. Under the Medical Act, Her Majesty was empowered to change the name of this institution, which had already enjoyed several aliases, to that of the Royal College of Physicians of Ireland. In England and Ireland a third class of medical practitioner exists, namely the apothecaries. Prior to the days of Henry VIII, an apothecary seems to have been the common name in England for a general practitioner in medicine. About that time shops began to be established for the exclusive sale of drugs and medicinal compounds, and those who kept these shops often took upon them to doctor their customers. In 1542 Henry's Parliament permitted any irregular practitioner to administer outward medicines, and these shopkeepers readily availed themselves of the permission granted by the Act, and pushed the sale of their drugs, and obtained larger prices on account of the advice they gave with them, and they appropriated exclusively the title of apothecaries. In 1617 they were incorporated under the name of the Master, Wardens and Society of the Art and Mystery of Apothecaries of the City of London. About the beginning of the 17th century they began to prescribe as well as supply medicine, and although the College of Physicians resisted this poaching on what they considered their preserves, still early in the 18th century the matter was settled in favour of the apothecaries, since which time they have been legally recognised as a branch of the medical profession. An Act of 1815 now regulates the practice of apothecaries throughout England and Wales, and no one can act as such or recover any charges for his services unless he has a certificate from the Society of Apothecaries. An apothecary is bound to make up any prescription duly signed by a licensed physician. Cresswell, J., considered an apothecary one who professes to judge of internal disease by its symptoms, and applies himself to cure that disease by medicine. And Glenn says that the practice of an apothecary may now be said to consist in attending and advising patients afflicted with diseases requiring medical, as distinguished from surgical, treatment, and prescribing, compounding, and supplying medicines for their cure and relief. The invention of medicine was generally attributed by the ancients to the gods, and both in Egypt and Greece female divinities were intimately connected with the healing art. Isis not only caused but cured disease. She discovered, so it was said, many remedies, and as late as Galen several compounds in the Materia Medica bore her name. Hygeia, the daughter of Aesculapius was deemed the goddess of health, and Juno presided at accouchements. These fables show that in the remotest antiquity woman practised medicine. The laws of Greece, at a later period, forbade women to practise. Thus also was it in Rome. However, 300 years before Christ, Agnodice, a young Athenian, dared to attend in disguise the schools of medicine forbidden to her sex. Preserving her incognito, when her education was finished she soon acquired a lucrative practice, and eventually her case caused the law against women to be revoked. In the Middle Ages, among Mohammedans, many women were skilled in attending to the needs of their own sex, and among the Christians, nuns as well as monks ministered to bodies as well as souls diseased, practising both surgery and physic. In Italy, at Salerno, women prepared drugs and cosmetics, practised among persons of both sexes, took doctors' degrees, wrote treatises on medical subjects, obtained the royal authority to engage in the art, and composed poems in praise of their science. At the University of Bologna, as late as 1760, Anna Morandi Manzolini filled the chair of anatomy. Her reputation was European, and her lecture room was frequented by students of all country, so great was her skill in delicate dissections, and so clearly did she demonstrate the wonders of the human form divine. Dr. Maria del Don was professor of medicine and obstetrics in the same college in 1799, and many were the lady graduates of the universities of Padua, Pavia, and Ferrara, as well as Bologna. In France, the earliest official document extant relative to the profession, dated 1311, forbids the practice of surgeons or female surgeons who have failed to pass the required examinations, and an edict of 1352 refers to female practitioners. In Spain, the universities of Cordova, Salamanca, and Alcala bestowed doctors' degrees on many women. In Germany also, a number of the fair sex successfully cultivated the science of medicine, and practised it, in the last century and in the early part of this. In England, as has already been seen, in early days women practised the healing arts. Henry VIII. Checked them for a time, but in his old age, changing his mind on this, as on almost every other subject, gave them liberty to minister to the outward and less serious ailments of his people. Crossing the Atlantic, an entry is found, under the date of March 1638, which tells a tale. It is this: "Jane Hawkins, the wife of Richard Hawkins, had liberty till the beginning of the 3rd month, called May, and the magistrates, if she did not depart before, to dispose of her; and in the meantime she is not to meddle in surgery or physic, drinks, plasters or oils, nor to question matters of religion, except with the elders for satisfaction." But now woman is no longer regarded as too good or too stupid to study medicine in America, and nearly every state in the Union has free access to medical colleges. The Council of the College of Physicians and Surgeons of Ontario admit to registration and practice any person who complies with their requirements, without regard to sex; and the Imperial Parliament, by an Act passed in 1876, affirmed the principle that women are entitled to become registered practitioners of medicine. End of Chapter 1.
Chapter 2 of the Law and Medical Men. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Recording by Rick Vina. The Law and Medical Men by Robert Vashon Rogers. Chapter 2. Fees. The Roman law considered the services of an advocate and of a physician as strictly honorific, and, as in the Roman age, practitioners in law and medicine were usually men of leisure and wealthy, who did not practice for the sake of a livelihood. Remuneration for their services could not be recovered in the ordinary way. Although owing to the utopian ideas concerning the honor of a liberal profession then in vogue, it was considered that any mention of a fee or a salary by that name would soil and disgrace the robe of a practitioner. Still, it was an established fiction of the civil law that the promise of an honorarium always accompanied the employment of a professional man, and that such promise created one of those obligations that might be enforced by action. The common law of England adopted the theory of the civil law as to the high standing of the profession, but afforded no remedy for the recovery of the charges. Surgeons and apothecaries were enabled to recover by law remuneration for their services, but a physician was presumed to attend his patient for an honorarium, something left to the honor of the patient to pay or not to pay, and could not maintain an action for his fees until the passing of the Medical Act, 1858, put an end to his anomalous position in this money-making age, and gave him as free an entrance into the courts of law to recover compensation for his work and labor, time and skill bestowed, as the worker in any other path of life. Before this, a physician could not recover even expenses out of pocket, such as those incurred in traveling to visit a patient, unless there had been an agreement specially made to that effect. If a physician was a surgeon as well, and attended a case where the advice of a physician and the aid of a surgeon were necessary, he could recover the value of his services as a surgeon, but not as a physician. In England, the question sometimes arises, where the practitioner is only a surgeon, whether he can charge for attendance as a physician or as an apothecary. It has been held that typhus fever is not a disease that belongs to a surgeon's branch of medicine, and that he cannot, therefore, recover for his attendance on a patient suffering under it. So, too, with regard to consumption and dropsy, though, in the latter case, he may recover for any work done for the patient specifically within his practice, such as puncturation, scarification, bandaging, and friction. At one time, it was considered that an apothecary was not entitled to charges for his attendances, but only for his medicine. Then the law decided that he might charge for either attendances or medicines, but not for both. Shortly afterwards, Tenterden held that one might recover for attendance, the charge being reasonable, as well as for medicine. After that, full justice was done to this branch of the profession, and it was decided that there was no rule of law, and there certainly is none of morals, to prevent an apothecary from making distinct charges for attendances and medicines. But if he charges very high for his drugs, the jury may think the attendances ought not to be paid for as well. In Scotland, also, at one time physicians' fees were regarded as honoraries, and not recoverable by action except under a special contract. Neither in the United States nor in the colonies have these distinctions been made between the different branches of the profession, nor has the principle been adopted that the profession of a physician is a merely honorary one, and that his services cannot be charged for. In England, every person registered according to the Medical Act, 1858, and in Ontario, those registered under the Provincial Act, can practice medicine or surgery, or medicine and surgery, and can recover in any court of law, with full costs of suit, reasonable charges for professional aid, advice, and visits, and the costs of any medicine or other medical and surgical appliances rendered or supplied to his patient. But no person is entitled to recover any such charges in any court of law unless he can prove upon the trial that he is so registered. Registration has now become a part of the plaintiff's title to recover, which it is imperative upon him to prove. A copy of the medical register for the time being, purporting to be printed and published under the direction of the General Council, is evidence in all courts that the persons therein specified are registered according to the provisions of the Medical Act, and the absence of the name of any person is evidence, until the contrary be made to appear, that such person is not so registered, and the contrary may be shown by a certified copy, under the hand of the registrar, of the entry of the name of such person on the register. Similar rules are in force in the various states where medical boards have been constituted by legislative authorities for the purpose of examining and licensing practitioners, such as Alabama, Delaware, Florida, Georgia, Louisiana, Maine, Minnesota, New York, Ohio, South Carolina, and Wisconsin. Subject to the various statutory enactments, every physician or surgeon, or any one who chooses to act as such, is entitled to a reasonable reward for his services and for his medicines. If there was no express promise to pay when the services were requested, the law implies one, the broad principle being that when a person has bestowed his skill and labor for the benefit of another at his request, and no agreement is made in respect to them, the law raises an implied promise to pay such compensation as the person performing the service deserved to have, and when there is no statutory or other restraint upon the remedy, an action lies on such promise. The amount, unless settled by law, is a question for the jury, and in settling that, the eminence of the practitioner, the wealth of the patient, the delicacy and difficulty of the operation, as well as the time and care expended, are to be considered. The law, as a rule, sets no limitation to fees, provided they be reasonable. Within this rule, a practitioner is allowed discretionary powers, and may charge more or less according to his own estimate of the value of his services. No one will pretend to assert that all services are of equal value, and no one will claim that those who can render them the most skillfully should receive only the same reward as those who can render them the least so. A medical man of great eminence may be considered reasonably entitled to a larger recompense than one who has not equal practice, after it has become publicly understood that he expects a larger fee, inasmuch as the party applying to him must be taken to have employed him with a knowledge of this circumstance. But doctors must not be unreasonable in their charges, as Lord Kenyon remarked, "Though professional men are entitled to a fair and liberal compensation for their assistance, there are certain claims which they affect to set up, which, if unreasonable or improper, it is for the jury to control." That a patient is a millionaire does not justify an extortionate charge. The French rule is to consider the gravity of the disease as well as the fortune and position of the patient in settling the remuneration of a physician. The existence of an epidemic does not authorize the charging of exorbitant fees. In some ages and countries, the fees payable to medical practitioners have been fixed by law. In Persia, for instance, in ancient times, the law said that, "A physician shall treat a priest for a pious blessing or a spell, the master of a house for a small draught animal, the lord of a district for a team of 4 oxen, and if he cure the mistress of a house, a female ass shall be his fee." Vendidad Farg 7. To take another instance, the medical men in attendance upon the old princes of Wales had their fees settled. For curing a slight wound, a surgeon received for payment the clothes of the injured person, which had been stained with blood, and for curing a dangerous wound, he had, in addition to the bloody clothing, board and lodging while in attendance, and 180 pence. In Egypt, according to Herodotus, practitioners were paid out of the public treasury, although they might also receive fees from their patients. A medical man can also recover for the services rendered by his assistants or students, and that even though the assistant is unregistered. It is not necessary that there should be any agreed specified price. He will be allowed what is usual and reasonable. The right of a medical man to recover his charges for professional services does not depend upon his effecting a cure, or on his services being successful, unless there is a special agreement to that effect. It does not depend upon the fortune of the case, whether it be good or bad, but upon the skill, diligence, and attention bestowed. For, as a general rule, a physician does not guarantee the success of his treatment. He knows that that depends upon a higher power. Still, some good must have resulted from his efforts. The rule appears to be that if there has been no beneficial service, there shall be no pay. But if some benefit has been derived, though not to the extent expected, this shall go to the amount of the plaintiff's demand, leaving the defendant to his action for negligence. The practitioner must be prepared to show that his work was properly done, if that be disputed, in order to prove that he is entitled to his reward. Where the surgical implements employed in amputating an arm were a large butcher knife and a carpenter's sash saw, it was held that the court rightly charged the jury that if the operation was of service, and the patient did well and recovered, the surgeon was entitled to compensation, though it was not performed with the highest degree of skill, or might have been performed more skilfully by others. If a surgeon has performed an operation which might have been useful, but has merely failed in the event, he is nevertheless entitled to charge. But if it could not have been useful in any event, he will have no claim on the patient. A medical man who has made a patient undergo a course of treatment which plainly could be of no service cannot make it a subject of charge, but an apothecary who has simply administered medicines under the direction of a physician may recover for the same, however improper they may have been. If the physician has employed the ordinary degree of skill required of one in his profession, and has applied remedies fitted to the complaint and calculated to do good in general, he is entitled to his fees, although he may have failed in this particular instance, such failure being then attributable to some vice or peculiarity in the constitution of the patient, for which the medical man is not responsible. It is the duty of a physician who is attending a patient infected with a contagious disease, when called upon to attend others not so infected, to take all such precautionary means experience has proved to be necessary to prevent its communication to them. When a physician who was told by a patient not to attend any infected with smallpox, or his services would be dispensed with, failed to say that he was attending such a patient, and promised not to do so, but continued to attend, and did, by want of proper care, communicate smallpox to the plaintiff and his family, it was held that these facts were proper evidence to go to the jury in reduction of damages in an action for his account, and that the physician was responsible in damages for the suffering, loss of time, and damage to which the plaintiff may have been subjected. If a physician, by communicating an infectious disease, has rendered a prolonged attendance necessary, thereby increasing his bill, he cannot recover for such additional services necessitated by his own want of care. This rule will apply with equal force to puerperal fever. In the case of vaccination, the physician, while he does not guarantee the specific value of the vaccine virus, yet guarantees its freshness, so that if he inoculate a patient with virus in an altered state, constituting as it then would mere putrid animal matter, and erysipelas or any injury to any limb necessitating amputation should arise, he will undoubtedly be held responsible for the suffering, loss of time, and permanent injury to the patient. Long since Lord Kenyon was of the opinion that if a surgeon was sent for to extract a thorn, which might be pulled out with a pair of nippers, and through his misconduct it became necessary to amputate the limb, the surgeon could not come into a court of justice to recover fees for the cure of the wound which he himself had caused. The physician, when sending in his bill, should be specific in his charges, and not general. He should give the number of visits and dates. In one case, a lump charge of $13 for medicine and attendance on one of the general's daughters in curing the whooping cough, being objected to by the valiant officer, was held by the court to be too loose to sustain an action. Where a practitioner brought an action for a bill consisting of a great number of items, and gave evidence as to some of them only, and the jury gave a verdict for the whole amount of the bill, the court refused to interfere and grant a new trial, because every item was not proved. Where a medical man delivered his bill to a patient without a specific charge, leaving a blank for his attendance, the court inferred that he considered his demand in the light of a quidam honorarium. This was before the Medical Act, and intended to leave it to the generosity of the patient, and the latter having paid into court a certain amount, the court held the surgeon was bound by the amount so paid, and could not recover any more. As a rule, however, if a doctor's bill is not paid when presented, he is not limited by it to the amount of his claim, if he can show that his services were of greater value. When witnesses are called to speak as to the value of the practitioner's services, the courts generally incline towards the lowest estimate. The number of visits required must depend on each particular case, and the physician is deemed the best and proper judge of the necessity of frequent visits, and in the absence of proof to the contrary, the court will presume that all the professional visits made were deemed necessary and were properly made. There must not be too many consultations, and the physician called in for consultation or to perform an operation may recover his fees from the patient, notwithstanding that the attending practitioner summoned him for his own benefit and had arranged with the patient that he himself would pay. Where a medical man has attended as a friend, he cannot charge for his visits. This was held in one case, where it was proved that the practitioner had attended the patient as a friend, upon the understanding that he was to have refreshments and dinners free of charge, and in another case, where a medical man had attended professionally for several years a lady with whom he was on terms of intimacy, but received no fees, except once when he had prescribed for her servant. The day before her death, this lady had written to her executors, asking them to remunerate the doctor in a handsome manner, and moreover in her will she gave him a legacy of £3,000, and a reversionary interest in £6,000 more. It was proved that he had attended others without having taken fees or sent in bills. It was held that his services had been tendered as for a friend, and accepted as a friend's, and his demand as a debt against the assets of the lady was rejected. One would have thought that the physician in this latter case should have been satisfied. Where a tariff of fees has been prepared and agreed to by the physicians in any locality, they are bound by it legally as far as the public is concerned, morally as far as they themselves are concerned. It is no part of the physician's business to supply the patient with drugs. If he does so, he has a right to be reimbursed therefor. If a physician enters into a special contract to perform a cure, he will be held strictly to its terms, nor will he be allowed to plead circumstances which, under the general law of professional obligation, might fairly exonerate him from blame, for failing of success in the treatment of his patient. To promise an absolute cure is to assume arrogantly the possession of powers never delegated to man. Only a weak and vapid intellect will commit so egregious a blunder. Yet, if a man choose to do it, he may, and having entered into an express contract, he will be held liable for its fulfilment. For it is his own fault if he undertake a thing above his strength. If the agreement is no cure, no pay, he cannot even recover for medicines supplied if the cure is not effected. At least, so it was held at Vermont. Contracts to receive a certain sum contingent upon the performance of a cure have always been considered as professionally immoral, and in the civil law were repudiated as against public policy. The physician is always allowed discretionary powers over the patient entrusted to his care in modes of treatment, so as to be able to alter them according to the varying necessities of the case. Unless such change of treatment involves a risk of life or consequences of which he is unwilling to assume the responsibility, he is not under obligation to give notice or obtain permission before making it. Particularly is this the case where the patient is not at home or among friends or relatives, but is in some degree in his custody, and under his exclusive supervision, as well as care. In such circumstances, he is authorized to perform operations, or change his treatment, or enforce discipline essential to its fulfillment, without first consulting or obtaining permission from friends or guardians at a distance, since delay might involve a greater risk to the health and possibly the life of the patient than would a necessitated operation. And of such things he alone is the proper, as he alone can be the best judge. He may recover his fees for such operation or change of treatment without proving that it was necessary or proper, or that before he performed it he gave notice to the party who had to pay, or that it would have been dangerous to have waited until such notice had been given. The burden of proving unskilfulness or carelessness in the operation lies upon the party objecting to it. When a medical man is called as a witness before a court, to testify as to facts within his knowledge, he must attend and give evidence upon payment of the same fees as other witnesses are entitled to, unless it is otherwise provided by statute. Where a statute provides that a medical man should be paid a certain witness fee, he is entitled to that fee, although he be not called to give professional evidence, and it is not necessary to prove that he is in practice. A witness should be paid his fees when he is subpoenaed, but even if he attends, he can refuse to give evidence until he is paid, unless he takes the oath before making the objection. A subpoena should be served a reasonable time before the trial, to enable a witness to put his affairs in such order that his attendance on the court may be as little detrimental as possible to his interests. Where a medical man is summoned to attend a coroner's inquest, unless the statute law is clearly to the contrary, he is only entitled to be paid for each day's attendance, not for each body on which the inquest was held. Under the Ontario Act, R.S. Cap. 79, a coroner, if he finds that the deceased was attended during his last illness or at his death by a duly qualified medical man, may summon that medical man to attend the inquest. If he finds that he was not so attended, he may summons any legally qualified neighboring practitioner, and may direct him to hold a post-mortem examination. But a second practitioner will not be entitled to any fees, unless a majority of the jury have, in writing, asked him to be called. The fees are, for attendance without post-mortem, $5; if with post-mortem, without an analysis of the contents of the stomach or intestines, $10; if with such analysis, $20, together with a mileage each way of 20 cents. If the practitioner, when duly summoned, fails to attend without sufficient reason, he is liable to a penalty of $40. Is an expert witness entitled to receive greater compensation than an ordinary witness, or can he be compelled to give a professional opinion without being paid for it? The States of Iowa, North Carolina, and Rhode Island have answered these questions by statutes which say such witnesses shall be entitled to extra compensation to be fixed by the court in its discretion, while Indiana says experts may be compelled to appear and testify to opinions without payment or tender of compensation other than the per diem and mileage allowed by law to other witnesses. The subject does not appear to have been very much considered in England. In a case at Nisi Prius, Lord Campbell declared that an expert was not bound to attend upon being served with a subpoena, and that he ought not to be subpoenaed, that he could not be compelled to attend to speak merely to matters of opinion. And Mr. Justice Maule, where an expert demanded additional compensation, said there was a distinction between a witness to facts and a witness selected by a party to give his opinion on a subject with which he is peculiarly conversant from his employment in life. The former is bound as a matter of public duty to testify as to all facts within his knowledge. The latter is under no such obligation, and the party who selects him must pay him for his time before he will be compelled to give evidence. Warden J. of the Supreme Court of Indiana, in considering the question, in a case that came up prior to the statute above referred to, reviewed most of the American decisions and the opinions of the text writers, and concluded, quote, that physicians and surgeons, whose opinions are valuable to them as a source of their income and livelihood, cannot be compelled to perform service by giving such opinions in a court of justice without payment. End quote. The court further said, quote, it would seem, on general principles, that the knowledge and learning of a physician should be regarded as his property, which ought not to be extorted from him in the form of opinions without just compensation. If the professional services of a lawyer cannot be required in a civil or criminal case without compensation, how can the professional services of a physician be thus required? Is not his medical knowledge his capital stock? Are his professional services more at the mercy of the public than the services of a lawyer? When a physician testifies as an expert by giving his opinion, he is performing a strictly professional service. The position of a medical witness testifying as an expert is much more like that of a lawyer than that of an ordinary witness testifying to facts. The purpose of this service is not to prove facts in the cause, but to aid the court or jury in arriving at a proper conclusion from facts otherwise proved. End quote. In an earlier case in 1854, in Massachusetts, the court said, quote, to compel a person to attend because he is accomplished in a particular science, art, or profession would subject the same individual to be called upon in every case in which any question in his department of knowledge is to be solved. Thus, the most eminent physician might be compelled, merely for the ordinary witness fees, to attend from the remotest part of the district and give his opinion in every trial in which a medical question should arise. This is so unreasonable that nothing but necessity can justify it. End quote. On a trial for murder, the prosecution had procured the attendance of Dr. Hammond to testify professionally, and had agreed to give him $500 as his fee. This fee was complained of as an irregularity, but the court, in delivering judgment, remarked, quote, the district attorney, it is true, might have required the attendance of Dr. H. on subpoena, but that would not have sufficed to qualify him as an expert with clearness and certainty upon the questions involved. He would have met the requirements of the subpoena if he had appeared in court when he was required to testify and given impromptu answers to such questions as might have been put to him. he could not have been required, under process of subpoena, to examine the case, and to have used his skill and knowledge to enable him to give an opinion upon any points of the case, nor to have attended during the whole trial, and attentively considered and carefully heard all the testimony given on both sides, in order to qualify him to give a deliberate opinion upon such testimony as an expert, in respect to the question of the sanity of the prisoner, and held that there was no irregularity in the payment of such a fee." Such text writers of high repute as Taylor, Phillips, Redfield, and Ordronaux all agree that an expert cannot be compelled to give professional opinions without proper remuneration. The last named writer says, "Where a subpoena is served upon an expert, he must obey it, if within the range of physical possibility. But once on the stand as a skilled witness, his obligation to the public ceases, and he stands in the position of any professional man consulted in relation to a subject upon which his opinion is sought. He cannot be compelled to bestow his skill and professional experience gratuitously. Whoever calls for an opinion from him, in chief, must pay him, and the expert may decline to answer until the party calling him has paid. When he has given his evidence, he cannot decline repeating it or explaining it. A similar rule will, by parity of reasoning, apply to personal services demanded from the expert, as well as to opinions asked." On the other hand, the Supreme Court of Alabama, in 1875, confirmed a fine imposed upon a physician for refusing to state the nature and character of a wound received by a man and its probable effect, upon the ground that he had not been remunerated for his professional opinion, nor had compensation for it been promised or secured. And the Court of Appeals in Texas, in 1879, held that the court could compel a physician to testify as to the result of a post mortem examination, adding that a medical expert could not be compelled to make a post mortem examination unless paid for it, but an examination having already been made by him, he could be obliged to disclose the results thereof. The result of the authorities seems to be that, without the aid of a statute, an expert cannot be compelled to bestow his skill and professional experience gratuitously upon any party, for his skill and experience are his individual capital and property. End of chapter 2.
Chapter 3 of The Law and Medical Men. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. The Law and Medical Men by Robert Vashon Rogers. Chapter 3. Who should pay the doctor? If Smith says to Brown, a medical man, "Attend upon Robinson, and if he does not pay you, I will," that being a promise to answer for a debt of Robinson's, for which he is also liable, the guarantee is only a collateral undertaking, and, under the statute of frauds, must be in writing and signed by Smith, or some other person thereunto by him lawfully authorized, in order to be binding upon him. But if Smith says to Dr. Brown, "Absolutely and unqualifiedly, attend upon Robinson and charge your bill to me," or "I will pay you for your attendance upon Robinson," then the whole credit being given to Smith, No written agreement is necessary to enable the doctor to recover the amount of his account from him, since it is absolutely the debt of Smith. Where a person calls at the office of a physician, and, he being absent, the visitor leaves his business card, with these words written on it: "Call on Mrs. Jones at number 769 High Street," handing it to the clerk in attendance, with the request that he would give it to the doctor and tell him to go as soon as possible, this caller becomes liable to pay the doctor's bill for attendance upon Mrs. Jones in pursuance of such message. Yet Mrs. Jones, if a widow, may also be liable, for one who acquiesces in the employment of a physician, and implies by his or her conduct that the doctor is attending at his or her request, is responsible for the value of his services. If Mrs. Jones is living with her husband, or without her fault away from him, the doctor has still another string to his bow, and may recover the amount of his bill from Mr. Jones, for the rule is that a husband must pay his wife's doctor's bills. Of course, the doctor cannot make all three pay. Long since, Justice Park was clearly of the opinion that if a mere stranger directed a surgeon to attend a poor man, such person was clearly liable to pay the surgeon. Yet in some cases in the United States it has been held that the man who merely calls the doctor is not bound to pay him. When, for instance, in Pennsylvania, a son of full age, when living with his father, fell sick, and the father went for the doctor, urging him to visit his son, afterwards the physician sued the parent. The court said this was wrong, that he should have sued the son, as the father went as the messenger only, that the son, who had the benefit of the services, was the responsible person, and remarked that it was clear that had the defendant been a stranger, however urgent he may have been and whatever opinions the physician may have formed as to his liability, he would not have been chargeable without an express promise to pay, as, for instance, in the case of an innkeeper or any other individual whose guest may receive the aid of medical service. A different principle, the court considered, would be very pernicious, as but very few will be willing to run the risk of calling in the aid of a physician where the patient was a stranger or of doubtful ability to pay. This was in 1835, and in Vermont one brother took another, who was insane, to a private lunatic asylum, and asked that he, the insane one, might be taken in and cared for. This was done. In course of time the doctor sued the sane one for his bill, but the court would not aid him in the matter, saying he is not liable unless he promised to pay. In the case of Mr. Dodge, above referred to, the court said he might very readily have screened himself from all liability by simply writing the memorandum on a blank card, or by adding to that which he wrote on his own cards something that would have apprised the doctor of the fact that he acted in the matter of Mrs. Jones as her agent. The reporter did not approve of this decision, and so appended the following graphic note: quote, "Let us see how this thing works. We will take as an illustration an almost everyday occurrence arising in the country. A.B. is taken suddenly and seriously ill in the night time, and sends to his neighbor, C.D., living in the next house to his, to have him go after the doctor as soon as he can, for he is in great pain and distress. C.D. jumps out of bed without hesitation, and hastily dresses himself, and goes out to his barn and takes a horse from the stable, and not waiting to put on a saddle or bridle, jumps on to the horse with the halter only, puts him at full speed for the doctor's office, some 2 or 3 miles distant. On arriving there, he finds the doctor absent from home, but his clerk is there, and C.D. at once says, 'Tell the doctor to call on A.B., who has been taken suddenly sick. Tell him to come as soon as possible.' In accordance with this message, the doctor calls upon A.B., and prescribes for and attends him professionally for several years. After a reasonable time, the doctor sends in his bill to A.B., and it not being paid as soon as the doctor desires, he calls on C.D., and requests him to pay the bill. CD, with perfect astonishment, asks why he is to pay. The doctor informs him that he made himself liable to pay the bill because, when he delivered the message, he did not tell the clerk that he came for the doctor by the request of AB, nor that he acted as agent of AB in delivering his message. Well, says CD, the fact was I did go at the request of AB, and merely acted as his agent in delivering the message, and I will swear to these facts if necessary. The doctor insists that it will do him no good if he should give such testimony, for the law is settled on that point, as just such a case has recently been decided in New York under just such a state of facts, where the jury in the justice court found a verdict for the doctor for the amount of his bill, and on appeal by the defendant to the general term of the New York Common Pleas, that court unanimously sustained the verdict of the jury, and affirmed the judgment of the court below. Well, says CD, if that is the law, I think I will wait a while before I go after a doctor again as an act of neighbourly kindness. End quote. This case was decided as late as March 1873. A wife has implied authority to bind her husband for reasonable expense incurred in obtaining medicines and medical attendance during illness, but this implied authority is put an end to if she commits adultery while living apart from her husband, and there has been no subsequent condonation, or if she leaves her husband's home of her own accord and without sufficient reason, and the fact has become notorious, or the husband has given sufficient notice that he will no longer be responsible for any debts that she may incur. If a husband turn an innocent wife out of doors without the means of obtaining necessaries, it is a presumption of law, which cannot be rebutted by evidence, that she was turned out with the authority of her husband to pledge his credit for necessaries, and in such a case medical attendance will be considered as one of the primary necessaries. A married woman's misconduct does not exonerate the husband from paying a doctor whom he requests to attend her. Although the law requires the husband to furnish the wife with all necessaries suitable to his condition in life, including medical attendance in case of sickness, still it gives him the right to procure these necessaries himself, and to decide from whom and from what place they are to come. If a physician attends a wife whom he knows to be living separate and apart from her husband, he ought to inquire whether she has good cause for doing so, for if she has not, he cannot make the husband pay the bill, and it has been held that it develops upon the doctor to show that there was sufficient cause for the wife's separation. The employment of a physician by a husband to attend his sick wife presumably continues throughout the illness, and the mere fact that the wife is removed, with the husband's consent, from his home to her father's, will not enable him to resist payment of the doctor's bill for visits paid to her at her father's. Notwithstanding the law's desire not to favour any particular school, a quack's bill was thrown out where the services were rendered without the husband's assent. This was done in a case where a doctor was in the habit of putting a woman into a mesmeric sleep. She thereupon became a clairvoyant, and prescribed the medicines which the doctor furnished, and for these he sued. The judge said, quote, "The law does not recognize the dreams, visions, or revelations of a woman in mesmeric sleep as necessaries for a wife for which the husband, without his consent, can be made to pay. These are fancy articles, which those who have money of their own to dispose of may purchase if they think proper, but they are not necessaries known to the law for which the wife can pledge the credit of the absent husband." End quote. In England, it was, until 1869, considered that a parent's duty to furnish necessaries for an infant child was a moral and not a legal one, so that he was not liable to pay for medicines or medical aid furnished to his child without some proof of a contract on his part, either express or implied. And this still is the view where the child is over 14. The rule of law varies in the different states of the Union. In most of those in which the question has come before the courts, the legal liability of the parent for necessaries furnished to the infant is asserted, unless they are otherwise supplied by the father. and it is put upon the ground that the moral obligation is a legal one, and some of the courts have declared this quite strongly. In other states the old English rule has been held to be law, and agency and authority have been declared to be the only ground of such liability. The authority of the infant to bind the parent for medical aid supplied him will be inferred from very slight evidence. But a contract to pay will not be implied when the infant has been allowed a sufficiently reasonable sum for his expenses. Where the services have been rendered with the parent's knowledge and consent, he will generally have to pay for them. A boy left home against his father's will, and refused to return at his parent's command. Being seized with a mortal illness, he did at last come back. His father went with him to a physician to obtain medical advice, and the doctor afterwards visited him professionally at his father's house. No express promise to pay was proved, nor had the father said he would not pay. The court held the father liable to pay the doctor's bill. And in an English case, where a father had several of his children living at a distance from his own house under the protection of servants, it was held that if an accident happened to one of the children, he was liable to pay for the medical attendance on such child, although he might not know the surgeon called in, and although the accident might have been received through the carelessness of a servant. By a recent English statute, when any parent shall wilfully neglect to provide adequate food, clothing, medical aid, or lodging for his child in his custody under the age of 14, whereby the child's health shall have been, or shall be likely to be, seriously injured, he shall be guilty of an indictable offence punishable by imprisonment. Charles Downs was the 2-year-old child of a member of the sect of Peculiar People. These people never call in medical aid or give medicines. To do so would be contrary to their religious opinions. But if any is sick, they call in the elders of the church, who pray over him, anointing him with oil in the name of the Lord. Then they hope for a cure, as they have thus literally complied with the directions in the 14th and 15th verses of the 5th chapter of the Epistle of St. James. This child was ill for months. The usual course was pursued by his father. No medical aid was obtained, although easily obtainable. The illness was misunderstood, and although he was taken care of and well supplied with food, the child died. The father was indicted for manslaughter, and the jury found that the death was caused by the neglect to obtain medical assistance, that the father bona fide, though erroneously, believed that medical aid was not required, and that it was wrong to use it. The judge entered a verdict of guilty, and the court held, under this statute, that a positive duty was imposed upon the father to provide adequate medical aid when necessary, whatever his conscientious scruples might be, and that the duty having been wilfully neglected by the prisoner, and death having ensued from that neglect, he was properly convicted of manslaughter. It had been held by Baron Pigot, in a case against these same Peculiar People, and also by Justice Willis, that at common law there was no legal duty upon a father to employ a physician for his sick child. It is not enough to show neglect of reasonable means for preserving or prolonging the child's life, to convict of manslaughter. It must be shown that the neglect had the effect of shortening life. It will not do merely to prove that proper medical aid might have saved or prolonged life, and would have increased the chance of recovery, but that it might have been of no avail. In this case the father, perhaps, might have been convicted of neglect of duty as a parent under the statute, per Justice Stephen. Medicines and medical aid are necessaries for which an infant may legally contract, and for which he can render himself liable. In Massachusetts it was held that he would not be liable merely because his father was poor and unable to pay. A master is not bound to provide medical assistance for his servant, but the obligation, if it exists at all, must arise from contract. Nor will such a contract be implied simply because the servant is living under the master's roof, nor because the illness of the servant has arisen from an accident met within the master's service, but where a servant left in charge of her master's children was made ill by suckling one of the children, and called in a medical man to attend her, with the knowledge and without the disapprobation of her mistress, it was decided that the doctor could make the father and master pay. And a master is bound to provide an apprentice with proper medicines and medical attendance. In England, when a pauper meets with an accident, the parish where it occurs is usually liable for the surgeon's bill. If, however, the illness of the pauper arises from any other cause than accident or sudden calamity, the parish in which he is settled is under legal liability to supply him with medical aid, although he may be residing in another parish. But all these questions with regard to paupers are determined according to the poor laws of the different countries. It has frequently happened that when a railway passenger or employee has been injured by a collision or accident, and some railway official has called in a doctor, the company has afterwards refused to pay the bill, and the courts have declined to make them do so, unless it be shown that the agent or servant who summoned the medical man had authority to do so. It has been held that neither a guard, nor the superintendent of a station, nor the engineer of the train in which the accident happened, had any implied authority, as incidental to their positions, to render their companies liable for medical services so rendered. The Court of Exchequer said, it is not to be supposed that the result of their decision will be prejudicial to railway travellers who may happen to be injured. It will rarely occur that the surgeon will not have a remedy against his patient, who, if he be rich, must at all events pay; and if poor, the sufferer will be entitled to a compensation from the company, if they by their servants have been guilty of a breach of duty, out of which he will be able to pay, for the surgeon's bill is always allowed for in damages. There will, therefore, be little mischief to the interests of the passengers, little to the benevolent surgeons who give their services. But in England it has been decided that the general manager of a railway company has, as incidental to his employment, authority to bind his company for medical services bestowed upon one injured on his railway. In Illinois a similar decision was given as to a general superintendent, although in New York judgment was given the other way. If an accident happen to a stage-coach, by which a passenger's leg is broken, or his human form divine is otherwise injured, the coachman has no authority to bind his master by a contract with a surgeon to attend to the injury; nor if a lamplighter, by neglect, burn any person, has he, or any officers of the gas company, power to bind the company by a contract for the cure of the injured person. If ordinary employees had such authority, then every servant who, by his negligence or misconduct, had caused injury to an individual, would have an implied authority to employ, on behalf and at the expense of his employer, any person he thought fit to remedy the mischief. Chapter 4